Testing 1, 2, 3. Testing 1, 2, 3. Test, test, test. Testing 1, 2, 3. Let me pull up the stream. Testing 1, 2, 3. Testing 1, 2, 3. Test, test, test.
Good morning, ladies and gentlemen. Our first case for argument this morning is United States against Robinson. Ms. Masters.
Good morning, Your Honors, and may it please the Court. Rick Masters on behalf of Tanya Robinson. Today I'm going to be addressing the defendant's joint argument on entitlement to acquittal on count 8 for wire fraud and stand on the briefs about her argument regarding correcting the clerical error in her judgment unless the Court has any questions. Ms. Robinson's conviction cannot stand because the government did not elicit sufficient evidence to prove the indicted offense that the September 22nd, 2017 drawdown wire for $80,000 was used to fund payment of fraudulent checks. And they can't show that beyond a reasonable doubt. Instead, the government pursued theories of conviction contrary to the indictment, the jury instructions which referred back to the indictment, the plain language of the statute, 18 U.S.C. 1343, requiring that the wire be for the purpose of executing a scheme to defraud, and this court's controlling precedent in Durham. Here, the government's theory in opposing the motion to acquit and the theory before the jury was that any wire would do during the course of the scheme because they all went into a central bank account used to fund repairs that was part of the scheme to defraud. But that same central bank account was used to fund actual repairs. And the government told the
Counsel, money is fungible. Do you think you have to trace dollars through a bank account? It doesn't work. It's not the same bills coming in and going out.
So, Your Honor, yes, we do think there is some obligation, not to completely trace, but there is some obligation, or a big obligation actually, to show beyond a reasonable doubt that this particular drawdown was used for fraudulent expenses. And the reason that exists is because we don't criminalize drawdowns that are used for legitimate purposes when an entity continues to engage in legitimate functions.
Really, Ms. Masters, the government has argued that evidence showed that Donnelly, for instance, had July and August invoices pending for payment at the time of the September 22nd drawdown. Couldn't a jury reasonably find that the funds from the drawdown were used to pay those pending invoices? And given that Donnelly didn't do any legitimate work, aren't those payments clearly in furtherance of the fraudulent scheme?
Your Honor, it doesn't meet the sufficiency of the evidence test in this case because, first of all, we dispute that they actually argued that before the jury on count 8. We have what they argued before the jury in our brief. They made that point later about Donnelly, but to your point in our opening brief, we point out that the invoices for Donnelly are pending in July and August, and there are multiple drawdowns that happen before he's actually paid out in November. So the government takes the position they don't have to trace money. They take it in their oral response to the motion to acquit. They take it before the jury. In fact, before the jury, they say, we just had to pick one, so any one that goes into the central account is fine. We then they make that Donnelly argument in their written response to the motion to acquit. The court agrees, the district court agrees. In Ms. Robinson's open brief, we point out that that money doesn't flow the way the government contends because there's multiple drawdowns, and they drop Donnelly in the response brief.
But when you look at the timing of the invoice, I think Donnelly is the name of a person, right? And
yes.
The contracting firm was called D Fresh Contractors.
Correct.
Is that right?
Yes. Okay.
When you look at the timing of this, one of D Fresh Contractors' invoices comes in at the end of August 31st, for like $12,300. And then we fast forward to the drawdown request on September 22nd of 2017. So within a month. And then within about 45 days of that, there's a check going out because HUD had funded the drawdown. Can't a jury find by this indirect and circumstantial evidence that part of that $80,000 was written out to defresh contractors?
No, for multiple reasons, and chief among them is that the government told the jury it didn't have to engage in
The
tracing
government's
money.
arguments, though, aren't the evidence. So when you look at the evidence and you look at the standard of review for overturning a conviction on sufficiency grounds, you know, you have to basically say this is entirely implausible. And I don't see how you can show that.
Well, I think when you look at cases like Barta and Ashburn, and it talks about what was argued to the jury, this isn't what was argued to the jury. And so what the government
But isn't everything I summarized as a matter of evidence before the jury?
But it's not argued that this is what the jury should be looking at. So now the government is saying we didn't tell the jury to be looking at this, but you can draw this reasonable inference from it, and we would suggest that that's not correct because there are legitimate repairs going on, and the record shows that there is a paper trail here. There's a paper trail that shows the purposes behind the drawdown, and the government just said they didn't have to get into it because HUD had to, the housing authority had to submit.
It seems
to
that you're
HUD.
arguing although disavowing it expressly, it seems like you're arguing for a tracing rule.
We are stating that Durham requires some amount of doing that when there is legitimate functions of a housing authority. I see
Is it your bottom line that the government has to trace a specific dollar to a specific invoice? Is that the bottom line for you?
No, the bottom line is that on this record, that the evidence before the jury was that there is a paper trail that was submitted to the housing authority, to HUD, because to get a drawdown, the housing authority had to submit to HUD what it wanted to use the funds for, and the government didn't bother to, as a sufficiency of the evidence matter, show that the funds weren't used to write checks for what the housing authority was seeking them for, and because it's beyond a reasonable doubt, they could have put in the request for the $80,000 for legitimate repairs and written checks the next day for $80,000 for legitimate repairs. And on the beyond a reasonable doubt standard and the sufficiency of the evidence standard, the government is not entitled to this inference, which is what they're saying, that the money went to illegitimate purposes, that the drawdown was for illegitimate reasons.
Mm-hmm. Thank you, counsel. Mr. Capobianco.
Good morning, and may it please the court. Joseph Capobianco on behalf of Albert Smith. I'd like to focus on Mr. Smith's bank fraud convictions because they are not sustainable as a matter of law. The record is devoid of any evidence that Mr. Smith or his co-conspirators obtained bank property by means of a false statement, which is an essential element.
Mr. Capobianco, why is this an issue that we can reach at all, given the absence of a Rule 29 motion directed to bank fraud counts?
Your Honor, the court can reach this under the plain error review.
No, the reason I'm asking this question is that the Supreme Court has held that in civil cases, in the absence of a Rule 50 motion, the civil equivalent to the Rule 29 motion, a court of appeals just cannot consider the sufficiency of the evidence. It's not before the appeal. Why shouldn't a Rule 29 motion be required in a criminal case, just like a Rule 50 motion is required in a civil case?
Your Honor, we would submit there's differences between the civil and criminal matters for the obvious reason that the defendant...
There are obvious differences, but the question is procedural. Why isn't... I can put it differently. The plain error doctrine requires first that the district court have committed an error. But if the district court was never asked to enter a judgment of acquittal, how can it be an error not to have entered one?
Your Honor, this court has said that it's error because the district court on its own motion did not move to...
Have we ever tried to reconcile that with the Supreme Court's holding in the civil cases?
Your Honor, I'm not familiar with...
Unitherm? The answer is no. Right? Unitherm's decided, it's now decided 20 years ago. We have been ignoring it in criminal cases ever since. and I wonder whether we're entitled to do that.
Your Honor, I would submit that allowing a defendant to be convicted of a crime where there's no evidence on an essential element of an offense, there's a reason that the court should, on appeal, address that.
Allowing a civil defendant to be ordered to pay $500 million without any evidence is also a gross injustice. But if the defendant doesn't make a Rule 50 motion, that's going to happen.
Your Honor, I think the injustice...
The injustice here, by the way, is, since these are concurrent sentences, it's the $100 special assessment. The injustice in the civil case is a lot bigger.
Your Honor, the injustice here is that Mr. Smith has 6 convictions for bank fraud when he has not committed bank fraud.
Yeah. The sentences of imprisonment are concurrent. If we were to reverse these bank fraud convictions, the result would be that the government would owe your client $600.
Your
That's
Honor,
all.
Your Honor, in other cases where there have been concurrent convictions with concurrent sentences on each count of the conviction, and this court has reversed one of those, in every single case, the court remands for resentencing.
Not in every single case.
So the cases in Chaparro, Davis, Clark...
There are cases where that's happened, where we thought it mattered, and there are cases where we thought it didn't matter.
And Your Honor,
I'm referring... I don't think you're understanding the nature of my question. The Supreme Court held in United States against Roy that as a result of the special assessment, the concurrent sentence doctrine no longer precludes appellate review. But I'm asking a question about steps 3 and 4 of Olano.
Your Honor, and this court has said that Olano's requirements for plain error are met in a sufficiency of evidence challenge when the record is devoid of evidence.
When there are concurrent sentences?
That's correct, Your Honor.
What case is that?
Your Honor, I believe Meadows was the case. 91 F3rd 851. And so we would submit that since there's no record evidence here of bank fraud, whatever theories the government has now submitted on appeal that weren't presented to the jury cannot be enough to sustain his conviction.
Regarding the bank fraud conviction, does it matter that the use of the bank account was a middle step in the scheme itself, in that the fraudulent drawdown request resulted in funds first being deposited into the Housing Authority bank account, from which the contractors could then withdraw the funds based on the checks that were issued on those fraudulent invoices. Where the bank account is used at both the front end and the back end of a scheme, does the bank become a pivotal part of the scheme itself? And does that affect the 1344-2 analysis?
No, Your Honor, that doesn't affect the analysis, because the requirement is that the false statement is the means by which the defendant got the bank property. So whether or not the bank is used up front or at the end or in both places, the requirement is still the same, that the false statement has to be the means by which the defendant got the property. And here there's no evidence of that. So whether or not the bank was involved at the beginning and at the end, the government still has not proven that essential element of the offense. Unless the court has further questions about Mr. Smith's sentence, I'd reserve the rest of the time for rebuttal.
Certainly, counsel. Mr. Temkin.
May it please the court. Good morning, Your Honors. Eli Temkin for the United States. This court should affirm.
And forgive me for interrupting so quickly, but the time is so short. And I would really appreciate your going into the bank fraud, because in Lauren, the Supreme Court held that where a valid check is obtained through a swindle, the means requirement of 1344(2) is not met. The court held that in such a case, the check is perfectly valid. So it is not itself a false or fraudulent means of obtaining bank money. And the false pretense that has led the victim to give a check to the fraudster has nothing to do with the bank that will cash it. Now, doesn't that describe the fraudulent scheme in this case? In other words, how is this case distinguishable from that held insufficient to demonstrate bank fraud in Lauren?
Yes, Your Honor. This case is distinguishable from the hypothetical set out in the Lauren case. As an initial point, the Lauren case actually affirmed and upheld the convictions, but Your Honor is referring to the hypothetical where the fraud is completed before the check is written. And that's what distinguishes this case from that hypothetical. To back up a moment, the legal principle at issue here is that anything that misrepresents someone's authority to access funds, essentially an agent's authority to act on behalf of the principal in a transaction, is a representation that can satisfy this by means of requirement. And that's set out in a number of cases that we've cited, for example, the Ayewo case from the First Circuit. So that's the nature of the misrepresentation here. And that gets to the point about
The
Lauren.
representation has to make its way to the bank, though. I mean, that's very clear in
Yes.
in Lauren.
Yes, Your Honor, absolutely. And so these checks are that misrepresentation or false pretense or fraudulent pretense. They're holding themselves out to be authorized housing authority expenditures. And
I
they
thought
are.
the Supreme Court has held, though, that a check in and of itself doesn't make a representation.
The act of depositing a check is not inherently a representation. That's the Williams case. This is different than that. A number of courts have held since Williams that
Yeah, I understand where you're going. What I don't understand is can you go back on your response to Judge Rovner's question? Because it's very hard for me to see a distinction between the handbag swindle hypothetical in Lauren and what happened here. I know this case doesn't involve handbags, all that. So, but on the principle of it, I don't see a distinction.
Yes, Your Honor, that gets to the heart of this, as Judge Rovner's question does too. The point here, what distinguishes it here, is that this check was part of the scheme. It was a key part of the scheme. That's how they're accessing housing authority funds. In the Lauren hypothetical, the fraud is done before the check is written.
It seems to me that the facts in this case present the type of fraudulent scheme that lacks a relational connection between the false statement and the inducement of the bank to part with its money.
The key difference here is that the fraudsters were on both sides of this transaction.
Hold on. Go back to, now you're changing the argument. Go back to the point. If I sell you, or I want to sell you, a knockoff Louis Vuitton handbag, the fact pattern in Lockwood, right? The fraud is not done until I get the check. I mean, I'm not going to declare victory in my fraud scheme until you hand me a check.
In that, in that situation, it's no different than if you were paid using cash. The fraud is done at that point. If you are the fraudster and you convince me to pay you,
you write me a check, and then I need to go to the bank and I need to turn the check into cash, and I go do it. The Supreme Court has said that doesn't cut it.
That's not close enough, exactly. And that's because the fraud is done when I give you the check. You've tricked me. You've gotten me.
What's the distinction though here?
Here, Tanya Robinson and Albert Smith were on the other side of this also. They were telling the bank to hand over housing authority funds, and they were doing that through the check. If the facts were the same, except Mr. Smith and Ms. Robinson weren't in on it, and no one at the housing authority was in on it, then it would be Lauren. Then the fraud is complete once they've tricked the housing authority and gotten the housing authority.
But why are you drawing those distinctions? Because in the Lauren opinion, the Supreme Court, Justice Kagan wrote it, she's not focusing on who is duped as parties to the transaction. What she's focused on is the language that Congress used in 1344-2 and whether a misrepresentation ever made its way to the financial institution. You're kind of breaking it down and saying, well, let's look at the culpability of the actors in the hypothetical. That wasn't relevant to her at all, or to the court.
Respectfully, Your Honor, the Lauren hypothetical does get to when the fraud is complete. And Justice Kagan, in her opinion for the court, talks about this relational requirement and essentially how proximately this has to be the means of affecting the scheme, affecting the fraud.
But isn't the bank's, involvement in the scheme wholly fortuitous? It's a function of the victims paying the fraudster by a valid check rather than cash.
Your Honor, this is not a valid check. It looks like a valid check. Everything about it looks like a valid check, which is what makes it a misrepresentation or a false or fraudulent pretense. It's pretending to be something that it's not. It's pretending to be an authorized housing authority payment. And that is the means by which they are accessing the housing authority funds held at the bank. And that's...
So what you're saying here, the check here is equivalent to a forged or counterfeit check?
Or altered or whatever.
Yeah, or an altered check, because the Supreme Court in Courtroom goes to great lengths to distinguish that and saying the handbag swindle hypothetical does not involve an altered, modified, forged, or counterfeit check.
Yes, Your Honor, this is the equivalent of a forged or altered check. And actually in the fact pattern presented in Lauren, the court upheld the convictions, and again, the actual facts there involved, at least in some instances, the fraudster...
The person swindled in the hypothetical thinks that they bought an authentic Louis Vuitton handbag. The housing authority here, or HUD, you can focus on two victims if you'd like, believe that they have paid for and received value for services.
The housing authority doesn't believe that. Tanya Robinson and Albert Smith created this scheme.
No. They're separate. The corporate entity is not the criminal defendant. The lawsuit is not the United States versus the South Bend Public Housing Authority.
Correct.
The lawsuit is against people.
Correct. And those
so all of a sudden the corporate entity has committed a crime?
No, Your Honor. These defendants have committed a crime by accessing the principal's funds without authority. And they've done that through these checks that tell the bank to hand over the principal's funds. And that's set out in cases we've cited, like the Morgenstern case, the Tiemann case, the Ayewo case. It's different because of the agency relationship here. These were not authorized housing authority payments. They used these checks. They had the ability to use these checks, and they did use these checks to tell the bank, the housing authority is authorizing you to take money from the housing authority's account and transfer it to the payee. And that's false, and that's fraudulent. The housing authority did not authorize that expenditure, and it didn't become an authorized housing authority expenditure just because Tanya Robinson said so. The housing authority has a mission, which is public housing. The mission is not to line the pockets of executives and contractors for work that never happened. And so by holding themselves out to be authorized housing authority expenses, these checks were fraudulent misrepresentations and pretenses to access the housing authority's funds held at the bank. Beyond that, these checks misrepresented who the payee was. The checks listed the contractors as payees, and these contractors were immediately turning around and funneling a good portion of these funds, usually most of these funds, back to these housing authority executives. The checks misrepresented where the funds were going, and that matters because if these checks had been made out to the executives directly, that would have raised flags. There's a reason they included the contractors in this, so that they could deceive the bank and deceive others into letting these payments go through. At minimum, this court's review is for a manifest miscarriage of justice. The court will affirm as long as there's any evidence by which the jury could have found that these were fraudulent representations and pretenses. There's ample evidence that the government presented through these checks, through the checks themselves, through the payees, that these were
Well, the plain error doctrine has more than one prong to it, right? When you say we're reviewing we have to apply the plain error doctrine, don't we?
Yes, Your Honor.
Which has four parts to the test.
Yes.
Okay. And what's your reaction to the question Judge Easterbrook asked of your adversary?
Your Honor, I can see the court going down that line. In this case, the government has taken the position, applying this court's precedent, that the court will review, and if there is a manifest miscarriage of justice here, if it rises to that level, if the evidence was so lacking that the district court was...
I don't see Olano cited in your brief, nor is Page, our recent en banc, about plain error. You didn't seem to be making any argument along the lines that I raised with Mr. Capobianco. What are we to make of that?
Correct, Your Honor. Again, in this case, the government has taken the position set out in the briefs. I'm not aware of...
Basically, you're willing to give them back the $600.
We've taken the position on the standard review set out in the briefs that if the evidence is that lacking, then the court should reverse. Again, I can certainly understand if the court wishes to go down the line of the other Olano prongs, also set out in Page. In any event, there is plenty of evidence here that these checks
Look, the burden of my question was whether a particular line of argument had been preserved, and I suggested that it had not. But the line of argument that I suggested was not preserved by the United States in its brief. And normally, non-preservation of a possible response based on non-preservation waives the waiver, as they say, or rather forfeits the forfeiture.
Correct, Your Honor. And I believe, I don't know the case to cite, but I believe the court isn't necessarily bound by the government's position, but the government's position is not to rely on...
You agree that we're reviewing for plain error?
For the bank fraud?
That's what the brief says.
Yeah.
Yes. Your Honor,
Okay,
that's
but
correct.
without reference to Olano, Page, or Rule 52B.
Yep.
I believe that's correct, Your Honor. And again, we were citing two cases that seem to address this specific situation. But again, if the court wishes to go back to Olano and to the more recent Page en banc decision, that is a line certainly the court could go down. If there are no questions as to wire fraud or the sentencing argument, the government asks the court to affirm. Thank you.
Yep. Thank you, Mr. Temkin. Anything further, Mr. Capobianco?
Yes, Your Honor. Just one brief point. The government seemed to shift its theory again. It said it mattered that Tanya Robinson and Mr. Smith were the ones cutting the checks. That was the case in Rodriguez, which is the Second Circuit case we cite, which was the exact same thing, except the defendant was the contractor rather than the person who was at the organization. And the Supreme Court actually in Lawrence cites that case. This is at 361 note 5. And they cite that case as an example of something that doesn't qualify as bank fraud. So the government's new theory, that they've raised for the first time doesn't even work. So we would ask that the court reverse Mr. Smith's bank fraud convictions and vacate his sentence.
Hold on, just Smith?
And Ms. Robinson as well.
Yeah, okay. That argument's made on behalf of both defendants.
Yes, Your Honor.
Right, okay.
Thank you very much. Ms. Masters, Mr. Capobianco, the court appreciates your willingness to accept the appointment in this case and your assistance to the court as well as your client. The case is taken under advisement. We'll hear argument now in the case of Milam against Celine Finance. Ms. Layton. Ms. Layton.
Good morning, Your Honor. May it please the court. Shelby Layton for appellant Ramona Milam. The district court held that Ms. Milam was barred from enforcing the FDCPA against Celine solely because she didn't comply with a notice and cure provision in her mortgage that on its face does not apply to claims against Celine. There are several independent ways that this court can reverse that holding, and I'm going to focus on 3 of them. First, the court erred by concluding that Celine can overcome the notice and cure provision's facial limitation to the lender because as a matter of law, it was an assign of the lender. Illinois law requires proof of an assignment, and Celine has offered none.
May I stop you there because I do have a question for you, which is why we should hold, as you argue, that the notice and cure provision is an unenforceable waiver of the lender's statutory rights under the FDCPA.
Sure, and the court doesn't need to get to...
I'm sorry, I took a breath. But if providing notice and an opportunity to cure to Celine would cause Celine to retract the misleading statements and offer the same damages that Milam could obtain by suing, wouldn't that strengthen rather than weaken enforcement of the rights that are protected in the FDCPA?
Sure, so I think there's 2 main reasons why this is an unenforceable waiver. Essentially, this provision serves only as a gotcha for consumers because it's impossible for any consumer, let alone an unsophisticated one, to tell when they're supposed to provide notice under this provision. They would have to anticipate Celine's argument that the word lender in the notice and cure provision doesn't actually mean lender. They would then have to go find Section 13 of the mortgage and read it the way that Celine reads it. And then they would have to find out whether Celine is in fact an assign of the lender, which is impossible to find out without seeing the contract between the lender and Celine, which we do not even have. Then they would have to figure out how to provide notice to Celine, given that Section 15, which describes how to provide notice, only talks about how to provide notice to the lender, not to the loan servicer. And so essentially, most consumers, if not all consumers, would not even know that there may be a possibility that they have to provide notice, let alone that they definitely have to provide notice in this situation. And then on top of that, as you referenced, any opportunity to cure would be futile because the statutory violation here has already occurred. Celine is wrong that it could have cured the violation. To be clear, we're not talking about just calling up Celine on the phone with a question about what the letter it sent means. What's contemplated by the notice and cure provision is that you're contemplating a judicial action and that you're providing notice in writing of a breach or a violation of the law. And so that means that Ms. Milam was required to give notice once she already knew that Celine's statement was misleading and was contemplating legal action under the FDCPA. And at that point, anything that Celine said wouldn't have made a difference because she already knows that there's a different timeline for foreclosure and that Celine had made a misrepresentation. And additionally, at that point, the statutory violation has already occurred. And as the Northern District of Illinois said in the Harrington case, at that point, Celine can't unring the bell. They can't go back and undo their statutory violation. Ms. Milam has a statutory right at that point to sue Celine, and nothing that Celine does or says is going to change that fact.
Ms. Layton, can I ask you a kind of a threshold question?
Sure.
And that is, you sure there's Article 3 standing here in terms of injury in fact? Because,
Yeah.
and the reason I say that is because it's clear that your client alleged a violation of the consumer protection statutes. That's as clear as day. But it's with respect to a debt that she already owed, right? And was late on. And I know she says, well, I had more time and it kind of caused me to juggle my money around and I had to accelerate, payment that way. But where's the allegation of actual harm here?
Yeah, so paying money sooner than she would have otherwise had to pay the money is enough for Article 3 standing.
No, I don't understand that answer. She had to pay the money earlier than she did pay it.
She
The
was
money was
late.
owed. The money was owed. It was already late. So I don't see how you can say she paid the money earlier than she had to pay it, in the sense of earlier than she had already promised to pay it. It may be that she just didn't want to pay, but paying money that you concede is already overdue is hard to see as a legal injury.
It's undisputed here that there would have been no consequences had Ms. Milam not paid this on day
Beside the
36
interest running on the loan.
Sorry?
Beside the interest running on the loan.
Sure, but there would not have been a foreclosure, there would not have been acceleration if she had not paid within this time frame. The consequences on day 34 are exactly the same as the
let me put it
consequences
here.
on day 36.
Do you have some case saying that it is a legal injury, a source of standing, to pay money that is in fact owed, was in fact owed earlier than it was paid, but that the plaintiff simply didn't want to pay?
So there's not a case saying exactly that, but in the Diffenbach case, this court did talk about how the time value of money, the loss of use of your money, even if temporary, is sufficient for Article 3 standing. And standing wasn't raised here or below or addressed by the district court.
Standing is an issue at all times in every case.
I understand, but if the court does have concerns about standing, we would welcome the opportunity to brief that issue and present case law on that point of whether this can be sufficient for
It just
Article
seems
3
odd. I
standing.
mean, it seems I understand how the letters could have been threatening, viewed as harassing, coercive, all of that. But they're all with respect to a debt that was already owed, was already behind in its payment schedule, and to which interest was already accruing. So when you try to so you'd say that's just all factual. That's just a factual observation, is all that is. So you say, well, so what's the harm then?
The harm is that but for this letter, she would have been able to make a payment to avoid acceleration and foreclosure at any time before 120 days before her loan was delinquent. And because of this letter, she made that payment, or she moved money around, she used that, and she tried to make the payment.
So the harm is that she lost a choice as to what she would do with her assets
That's right. She lost, it's not only a choice of what to spend the money on, but she lost the use of that money for the remaining days that she otherwise would have been able to use that money for other things, and instead had to put it to this within 35 days instead of within the 120 days. And that is the harm, and that's an economic injury regardless of, what the size of the injury. It is still sufficient for Article 3
Is it her
standing.
contention that she was earning more on that money than the amount of interest running on the loan?
I think it's not just the amount that she would have earned on that money, although sometimes courts do look at the interest rate to determine the time
I
value
could
of money.
understand a loss if you have a loan at 10% and you say, I've had to withdraw this from an investment that was making 15%. But I didn't see such an argument. We'll call for supplemental briefs from the parties, and if there's an argument of that kind available, please do present it.
Yes, that's right. I think that I'm not sure about the answer to your question about the interest, and I think that would be a reason to order supplemental briefing so we can develop those facts. None of those facts were developed in the district court, and it may be appropriate for the district court to address those facts in the first instance.
Well, you have to tether it to what's alleged in the complaint. So keep that in mind when you prepare yourself, right? It's not just a matter of just brainstorming on appeal.
No, I understand.
Right? Yeah.
But we would welcome the opportunity to brief that issue. I want to just.
Let me just, Celine didn't seem to contest that the lost time value of money can demonstrate actual damages, but it did argue that Ms. Malem did not present that theory to the district court, and that it is waived.
That's right. They do not appear to dispute that time value of money is sufficient for actual damages. And we did argue, and Ms. Milam argued below, that she paid money that would have gone to other sources towards her balance with Celine. That's at paragraph 102 of the complaint. And then in her opposition to the motion to dismiss, at appendix 142, she argued that that was sufficient for actual damages. So Celine is wrong that she did not raise this below. There's no requirement that she use the particular phrase time value of money because she described the concept of spending her money on other things rather than on her balance with Celine.
Of course, you argued in the brief that premature payment is itself an inherently economic loss because of the time value of money. But did you set forth any details as to what the money would have been used for if it hadn't been diverted for the payments? So to allow that inference, even if we normally would liberally construe the allegation, should that same construction apply here where the allegations were held insufficient in the first amended complaint, and not revised in the second amended complaint?
The standard that applies to a motion to dismiss is the same as to the first amended complaint as to the second amended complaint, and the allegation that she paid money that would have gone to other sources towards her balance with Celine is, if taken as true, is sufficient here to plausibly allege actual damages under Illinois law, and that she did not, to answer your question, allege specifically what those other sources were, but at the motion to dismiss stage, the allegation that she would have spent the money on other things, and in fact, the allegation that she just paid sooner than she otherwise would have, is enough to show the loss of the time value of money, because it's not what she would have spent the money on, it's the fact that she lost the use of that money for any reason, whether she wanted to spend it on necessary expenses or invest it in the stock market.
Counsel, I hope you see why when you file your supplemental memo, that line of argument will not suffice. It won't suffice because interest was running on the loan. You need to show that there was a loss compared with the extra interest that had to be paid. And that's where you need to focus attention.
I understand. Thank you, Your Honor. I'd like to reserve the rest of my time for rebuttal, if that's
Certainly, counsel.
Thank you.
Mr. Settleman.
Thank you, Your Honor. Misha Saitlin for Celine. I'd like to start with Article 3 standing. In this court's decision in Pinnell 990 F3rd 1041 and in Burnett 982 F3rd 1067, this court held in the FDCPA context that while just a bare allegation of the FDCPA violation and the emotional stress that would cause is insufficient for Article 3 standing, if a plaintiff acts to their detriment on a Dunning letter, that's sufficient. In paragraph 102 of the plaintiff's complaint, found in Appendix 36, paragraph 101, I apologize. Appendix 36, plaintiff alleges that as a result of the letter, she began making plans for her daughter to live elsewhere. While that is not sufficient under Illinois law, under the actual pecuniary loss doctrine, which is why we raised the argument for dismissal of those claims, we think making plans for your daughter is acting to your detriment. Now we are just at the motion to dismiss stage, and standing, as Judge Easterbrook pointed out, has to exist through the whole case. And if the court reverses the grant a motion dismiss, which we hope the court won't, we can certainly have factual development as to what steps the plaintiff took to her detriment to begin making plans for her daughter. But at this stage, we got a well-pleaded allegation, and so we thought that was enough for Article 3 standing and to proceed with the case. Now, of course, if this court, notwithstanding that focus on the plans for the daughter, which wasn't discussed in the briefing here because we were talking about Illinois law, we're making plans for your daughter unless it involves out-of-pocket money.
I don't see what Illinois law has to do with the standing issue. Illinois law can have whatever standing rules it wants, but federal court has its own standing rules.
Of course.
If you've listened to the conversation we've had already, you'll see where the supplemental briefs need to go.
Fair enough, Your Honor. I was just pointing out why we didn't talk about the making plans for the daughter when we were talking about the actual pecuniary loss argument that the district court accepted, because that wouldn't be enough for Illinois law, but it would be enough for Article 3 standing, which we will discuss in our supplemental submission that this court is ordering. Now, with regard to...
Mr. Saitlin, let me ask you this. How can we, at this point, determine whether Celine is merely hired for a service or is an assign of the lender, and the extent of any rights and duties assigned without factual development of the record, at least to encompass the agreement between Celine and the lender or other involved parties?
Under Illinois Toolworks, the only thing required under Illinois law to have an assignment is some identifiable interest being transferred. Your honors have on Appendix 125 the notice of assignment, sale, or transfer that we had to provide to the plaintiff. My friends cite that notice in their brief here. I think it's fairly, since it's specific of reference in paragraph 37 of the complaint, Appendix 26 is fairly included within the complaint, and that notice of assignment, sale, or transfer certainly shows that we were assigned some identifiable interest, which is all that's necessary to trigger Section 13 of the contract.
What do you say about cases like Bayview Loan Servicing?
I apologize.
It's a case in which the Illinois Appellate Court held that a loan servicer was not an assignee for purposes of a contract like this. Illinois Toolworks is not about the question before us. It has general language, right? So this is a case under Illinois law. So the question is, what have Illinois courts said about the question whether a loan servicer is an assignee? Bayview Loan Servicing says that it is not. There are other similar cases in Illinois law which your brief doesn't mention. Now, to be fair, I don't think Milan's brief mentioned Bayview Loan Servicing either. So it sent us off on a search through Illinois law to see what they've said about loan servicers as assignees. But that's where we need to go in order to figure out what the right answer is under Illinois law.
Right, Your Honor, and I'm not familiar with any Illinois law any law case.
But there is some, whether or not you found it. We found it.
Well, with apologies, Your Honor, as you know, we read the standard on Illinois law is that you just need some identifiable interest. And if you take a step back in this provision, the way that the contract works is you got to take the bidder of the suite. Why did we have to give them the notice under Section 22 in order to foreclose and accelerate to begin with? That's because we have certain obligations under the contract. And the other side of that notice obligation under Section 22 is they've got to give us notice and an opportunity to cure.
How do we know that an identifiable interest has been transferred as opposed to by contract a responsibility assumed by your client? In other words, that they just took on the act of collecting. They didn't get an interest in the contract, and they took on the act of collecting in exchange for compensation.
Yeah,
But what does that mean? In other words, what I'm trying to figure out is the Illinois Supreme Court has distinguished between an assignment and a delegation of responsibility, for better or for worse. They have. So in keeping with Judge Rovner's question, it's hard to look at this and just from the pleadings, categorically conclude, oh, this is an assignment. I mean, maybe, but why? It could be a delegation, couldn't it? A delegation of responsibility to collect.
well, I mean, look, you have to look at the contract as a whole and read it sensibly. What sense would it make if the lender had decided to do its own servicing and has sent the exact same letter, word for word? By the way, this letter tracks Section 22, and they brought that lawsuit. That clearly wouldn't be allowed without a notice and cure letter from them. But if they assign to us the servicing obligations, we still, and I don't hear them disputing, have to send that notification under Section 22. But they then don't have to send the notice and cure. They make a big deal out of the fact that Section 20 distinguishes between the roles, says that the servicer doesn't have to be the lender. Having said that, they allege in their complaint, and they admit, and this is, that the servicer and this lender could do its own servicing. So they would have to say that, reading that contract in full context, that the usual normal decision, which is not required, to contract out and assign servicing rights.
I get what you're saying completely. Bank of America, J.P. Morgan Chase, Citibank, they could make a choice to service their own mortgages. They could make a choice to contract it out. But to observe that they contract the collection out, I don't know that answers the Illinois law question of, do we have an assignment or do we have a delegation without more? I don't know.
Yeah,
I mean, you can say, well, it sounds like an assignment. Maybe. But we know that the law distinguishes between the two.
I understand that, but reading the contract to make sense, if they're right, the consequence would be that, I guess, if we wanted to foreclose and accelerate on the loan, we no longer would have to even send them a notice under Section 22 because we're not the lender. The way that I read the contract together is you got to take the bidder with the suite. If we have to give that notice under Section 22 in order to give them a 30-day heads up that we're going to accelerate and foreclose. Yes.
May I just say, sort of bottom line, I mean, the legal status of Celine in this case, it's both relevant and cannot be ascertained absent, for me, further factual development. If indeed Celine is a successor or a sign of the lender, then it can seek the benefits of the notice and cure provision. If it is simply an entity hired to perform a service, but not a successor or assign, it cannot. And the answer depends on the nature of Celine's relationship with the lender. And that question, for me, can't be answered at this time. I mean, for me, at a minimum, the documents that establish the legal relationship between Celine and the lender or its successor or assign would be relevant to making that determination. And of course, at this point in time, we take the allegations of the complaint as true. And she has alleged that Celine was delegated only limited servicing rights. So that's where I am, unless you can convince me otherwise.
Your Honor, obviously, if Your Honor doesn't think that the notice of assignment, sale, or transfer of servicing rights found at Appendix 125 is insufficient, then Your Honor will agree with us that the district court can be affirmed on the notice and cure basis. I would ask Your Honor to look at Appendix 125 if Your Honor thinks more factual development is necessary, and maybe it relates to the Article 3 standing inquiry as well. You know, I suppose a remand more globally would be would make sense.
That's part of the letter, though, that's the letter, right, that Celine sent out saying, hey, we, Celine, are now to the plaintiff. We're now servicing the mortgage.
That's right. And we think that letter, which is titled Notice of Assignment, Sale, or Transfer of Rights, is sufficient under Illinois law. Now, I hear from Judge Rovner that, to her mind, that is not sufficient. If that's the case and more factual development is necessary on that, then, you know, unless the court accepts our alternative argument that the face of the letter is not false or deceptive as a matter of law, then remand would be required for whatever factual development this court thinks is necessary on that basis. Now, with regard to that alternative argument, I take my friend's point that this court usually doesn't determine things in the first instances, but this was an argument that we raised below, and obviously, you know, the district court didn't rule on it. Now what all the letter does in our respectful submission is essentially track what Section 22 of the security instrument says we need to do, and this is a security instrument. You can look at the second page of it. It's just a standard instrument, for loans, and we just followed what it said. The plaintiff's complaint with the letter seems to be that we didn't enumerate other legal barriers that could attend to the timing of when the foreclosure in particular would need to occur. But the letter says May on its face. It's a standard letter that just tracks what Section 22 says. It's exactly what we needed to provide.
Not exactly. I think the actual language is not nearly as benign as Celine, as you assert. And I don't think it's so clearly I see problems. May 22nd is well before 120 days. And under the regulations that even Celine recognizes, Celine can't, in fact, proceed with the foreclosure at that time. And that limitation, for me at any rate, is not clear at all from the language. Instead, the language states that as of that failure to cure, Celine may proceed with the foreclosure. So for me, at worst, it's a false statement. And at best, it's potentially misleading, because we do not expect mortgage holders to know that the federal regulations will require Celine to delay foreclosure further until 120 days. And I guess my thinking at this point is that at a minimum, it raises a question of fact that would not be amenable to dismissal for failure to state a claim.
Judge Rover, I'm sorry I'm not able to convince you in any of my arguments this morning, which is obviously unfortunate for me. I mean, I will just say that I think the May language, similar to the May language in the Dunbar case where this court affirmed the dismissal where they said it may have tax consequences.
I don't think you're getting the point of my colleague's question. May says it's optional to do something within 35 days. The question is whether there is a legal rule requiring a loan servicer to wait for 120 days. If there is, then May is false. So, is there such a legal rule?
Yes, there is. However,
then May is false.
I disagree with that, Your Honor.
It would be a violation of law for your client to commence the process 40 days, 50 days, 60 days, and so on.
That's right, Your Honor, but we did not say that we would do it immediately. And if the letter read as a whole, it says, if you can't cure this default, contact us. We want to work with you. Here are the various steps that are going to occur if you do it. I don't think the standard is the unsophisticated debtor would look at that and say, what this letter is actually having the word immediately in there. I think what the letter fairly read says is, you owe the debt. You got to pay within 35 days, which is, by the way, less than the time frame in Section 22. But if you got a problem with that, contact us. And it says in bold, we want to work with you. We want to work with you is not the kind of language, when paired with May, that an unsophisticated debtor would think that
Okay,
we're
I
going to be
think we
foreclosed
have your
on.
position, counsel.
Thank you, Your Honor.
Ms. Layton, anything further?
Yes. I would just like to briefly address their argument about the assignment and the whether, as a matter of law, this can be decided. In the Dominguez case that involved both Celine and the same lender as here, it turned out after discovery that Celine was not an assign. The lender had retained all ownership of the servicing rights and had merely hired Celine as an independent contractor to service the loan. So that is likely to turn out to be the case here. So it is certainly not true that because Celine services the loan, it's automatically an assign that can enforce the notice and cure provision. Additionally, they argue that under Section 22, Celine is required to provide this notice, and so therefore they're suggesting that we can't have it both ways. But in fact, Section 22 imposes a requirement on the lender that the lender can choose to fulfill by hiring a loan servicer like Celine to act on its behalf. That doesn't mean that it is assigning its rights to Celine to service the loan. It just means that it is hiring Celine to send this notice on its behalf, which is what happened in Dominguez and is likely what is happening
Thank you,
here.
counsel.
Thank you.
The court directs the parties to file within 14 days supplemental memoranda addressing the question whether plaintiff has standing. When those memos have been received, the case will be taken under advisement. And now the court will take a 10-minute break before calling the third case. We're ready to resume argument, and now we have Hinks against Reddy. Ms. Major.
Thank you. May it please the court? Arbitration awards deserve deference, but even deference has limits. This case.
Ms. Major, before we get to the substance of review of arbitration,
Sure.
I wonder about subject matter jurisdiction. Subject matter jurisdiction appears to depend on diversity of citizenship, but the plaintiff is a citizen of Illinois, as is Mr. Reddy. So how do we have diversity?
Well, this, where we're at right now, procedurally, is we're seeking review of this arbitration agreement and the actions of the arbitrator in carrying out the terms of the arbitration
I understand
agreement.
that you're challenging what the arbitrator did, but if the district court does not have diversity jurisdiction, you can't do that.
That's correct,
And
Your
so
Honor.
far as I can see, the district court doesn't have diversity jurisdiction because citizens of Illinois are on both sides of the case.
But at this level, right now, on this appeal and in the court, the district court, we're only
The district
challenging.
court does not have diversity jurisdiction. It doesn't matter what relief you're asking for or who you are asking for relief from. If you sue nominally under the diversity jurisdiction, and a citizen of state A is a plaintiff, and there are citizens of states A and B as defendants, the only thing the district court can do is dismiss the suit. You can't order relief against defendant B. You're assuming that the judge can, but that's not right.
Well,
Now, if Reddy were dismissed as a party, that would solve the problem. But Reddy seems to be a party. We checked to see whether he had ever been dismissed.
well, the proceeding that was in front of the district court was a proceeding just seeking review of the decision
There is
between.
jurisdiction of a case, or there is not.
Okay. Well, Your Honor, the way I understand the law is that what's going on right now is we're seeking to enforce the contract as against just one party and for that party. But that's not my position. I mean, that's how I understand it. And there's nothing, I can't go beyond that, but that is what we're doing here, is just challenging the contract as to one party.
Sunera?
Exactly.
Have you considered exercising your rights under 28 U.S.C. 1653?
Your Honor,
It's the statute that permits the amendment of jurisdictional allegations, even in the Court of Appeals.
Well, if that's the case, then I would seek it because we are only proceeding against Sunera. And for Sunera, there is diversity. So, and I understand, Your Honor, and it was, something we looked at, but we are only seeking to enforce the contract and to
It's
seek.
not a question of what relief you are seeking. I hope I'm plain. There has to be diversity jurisdiction. You can't manufacture diversity jurisdiction by saying, well, I've sued a non-diverse defendant, but I'm not seeking any relief against him. That doesn't work.
Okay. Well, Your Honor, I'm fine with amending it, but all I'm telling you is the way I'm interpreting the law, which is that the proceeding in the district court in here is solely, as I understand what the courts have said, is essentially a breach of contract matter in the district court of the arbitration agreement. I'm certainly not basing it on the underlying claims, for which there would be clearly diversity, which is Title VII or the Americans with Disabilities Act. But I am saying that when we seek review, we are only seeking review of the contract and the arbitrators.
And what case do you rely on for the proposition that you can use the diversity jurisdiction in a case with a non-diverse defendant to seek relief against some other defendant?
I'm not sure there is a
I don't
case
think
on
there's
on
any
point.
case holding that.
Right.
That's your problem.
Right. But there's always a case of first impression. So, Your Honor.
Look,
Okay.
the United States diversity jurisdiction has been around for more than 250 years. Right? The Supreme Court has said that complete diversity is essential. That's the ruling of Strawbridge. It's the foundation of our understanding of the diversity jurisdiction. there's no exception to Strawbridge for cases in which I only want relief against the non-diverse defendant. Strawbridge is what it is.
But all I'm saying is that the review.
You don't want to spend your time arguing about this.
Okay.
You have a remedy under Section 1653, but whether you use it is
Well,
up to you.
Your Honor, I'm happy to assert that right now. And
No, you can't do that.
Okay.
Read the statute and follow the statute.
Okay. So going on with the issues that we've raised here. I mean, do you want me to continue to argue the issues here?
This is your only chance.
Okay. Your Honor.
Okay, I'll start you off.
Okay.
Why should Williams' testimony regarding Palmieri's statement be considered hearsay here, where it is not used to establish the truth of the matter?
Well, Your Honor,
Isn't the relevance of that testimony to establish what Reddy had been told as to her reputation with Oracle, not to prove that she in fact acted in some, unprofessional manner?
Well, the problem is that under federal case law, my client can defeat their claim, their pretext. We call pretext. She can defeat it by proving that, for example, Ms. Palmieri never even made those statements. Okay. So if we had had a chance to know that Ms. Palmieri was a witness, which she's never been identified in a single document ever in this case as a witness, not an answer to discovery, no deposition, nothing.
But Mr. Williams was, and had you deposed him, probably, I would imagine, this would have come out.
But that's not, Your Honor, that's not how the Michigan court rules work or the federal rules of civil procedure. You can't give one witness and conceal another witness and say, well, maybe they'll figure it out if they depose every single person that we've identified. They had an affirmative duty to disclose everybody who had information, and that certainly included Ms. Palmieri. And if they had disclosed her, and if they had said, she has information that Mr. Reddy relied on in making this determination, we sure would have deposed her, okay?
Well, the arbitrator never mentioned Palmieri's statement regarding Ms. Hinks in discussing the basis for the
Yes, he did. In fact, the arbitrator confirmed, in the testimony, they said it was the last straw, the defendants did. And the arbitrator, two comments, very significant in his ruling. One, he says, just before that statement was learned, what was the status of Ms. Hinkes's employment? Would she have been terminated without the Palmieri statement, or would she not have been? And this is what the arbitrator said. The emails that were sent out before the Palmieri statement.
Where are you looking at, just so we can?
This is the PSA page 3.
Okay.
Were incompatible with having already decided Hinkes was to be terminated. One statement by the arbitrator. Another one, the email that was sent out before the Palmieri statement reveals the opposite of a termination decision. Those are quotes from the arbitrator. So the arbitrator, this isn't a case where at the time of the Palmieri decision, the arbitrator found, oh, well, there are other reasons that also factored into this. The arbitrator found that there were no, at that time, they were not going to terminate my client. Then this mysterious statement, never disclosed anywhere, comes up. By a witness never disclosed anywhere. They were required under this arbitration agreement to follow the Michigan court rules and the AAA rules, unlike many of the contracts that come before this court where the arbitrator has discretion to follow or not follow.
Can I just get one question in here
Sure,
before you? Okay. So I understand your theory here, okay? What I don't understand is how it has anything to do with gender, race, or national origin discrimination.
I'm only.
Go ahead.
I believe I'm only. All of this comes down to the issue of, was the reason for the termination pretextual? That's the issue. Okay, and she filed it under several statutes. He found that they were lying, and he found that her disability did factor into this. So he found that that her termination was motivated by her disability.
So if you have a federal claim, if your client has a federal claim, it's an ADA claim.
Yeah, and I believe that's what we're proceeding on in this appeal. I think it's under the ADA.
Well, all right, there's a whole, I mean, there's...
The complaint does. The complaint had more claims. But I believe the appeal, because what he found was, he made a finding that her disability did factor into her termination, but he found that this final straw...
Yeah, I understand. I got it. It wasn't clear from the briefs to me as to what's going on with the federal discrimination claims.
Okay.
There's a whole bunch of them.
Okay. Well, it is the
Okay,
AD.
thank you, counsel.
Okay, thank you.
Mr. Skowski.
Good morning, judges, and please the court. Matt Swikowski is counsel for Appellee Sunera Technologies. Judges, Appellant Hinkes asks this court to reverse the district court's confirmation of the arbitration award, which is unprecedented relief in the circuit. Hinkes does
I
not
have the
cite...
same question for you that I had for Ms. Major. Why is there subject matter jurisdiction in this case?
Your Honor, Ms. Hinkes was asked to file an amended jurisdictional statement earlier in this appeal, and I believe she clarified that she's only proceeding this appeal against Sunera Technologies, Inc., which is a Michigan corporation.
I know that's what she says. You're not dealing with my question. Why is there subject matter jurisdiction in this case?
If she's only proceeding...
Her assumption is that if you... Well, I've already gone through this. You heard the question.
Yes.
How is it that without complete diversity of citizenship, there can be relief against any defendant?
I think that the 1653 statement that Your Honor pointed out earlier would be in order. I believe she's intending to go only against Sunera.
So in other words, your view is that there is not subject matter jurisdiction.
As currently postured and pled, with the inclusion of Mr. Reddy, who is an Illinois citizen, as you pointed out, there are Illinois citizens on both sides of the V currently, Judge. In any event, judges, Hinkes does not, as I mentioned, she does not cite a single case from this circuit to justify her unprecedented request for relief vacating the arbitration award under 10A3 and or 10A4 of the FAA. These narrow grounds to vacate an arbitration award have never at any time been successfully applied to overturn an arbitration award in the circuit. And the facts of this case, judges, are certainly not grounds for this court's first decision in its history to apply 10A3 and or 10A4 to vacate an arbitration award. Indeed, Hinkes' minor evidentiary quibbles are not even supported by the record. She argues that she's entitled to a requested relief for two reasons. First, as your honors know, she complains that Tara Palmieri, an individual that importantly was never called as a witness at the arbitration hearing, should have been listed in Sunera's initial disclosures. This is a new theory. Hinkes did not make any objection at the arbitration that anyone had not been properly disclosed. Her only objection at the arbitration was on the basis of hearsay. But even if Hinkes had made such an objection at the arbitration, it would have been properly overruled. The applicable Michigan court rule, like Federal Rule 26, does not require disclosure of any and all conceivable persons who may have knowledge of any aspect of the case. They are intended, judges, for disclosures of persons with information that the disclosing party may quote.
I must say, maybe I should have said this during Ms. Major's argument, but I don't understand what any of this has to do with the federal statute. The federal statute says that an arbitrator's decision may be set aside for misconduct. The plaintiff's assumption is that an error is the same thing as misconduct, and you seem to be engaging the same assumption. But we reverse district judges for making errors all the time, but we don't say, and therefore Judge X has engaged in misconduct. We say Judge X has made an error. That's the line drawn by the federal statute. There's a difference between making an error and engaging in misconduct.
Absolutely.
So why should an error be the same thing as misconduct?
I don't believe an error is the same thing as misconduct, far from it. I'm saying that they have not cited any case to say that this is misconduct, and in addition, Judge, there was no error. That's my only point in getting to the minutia of
But I
this
don't
evidentiary rule.
think that under the Arbitration Act, whether there is an error matters.
I fully
Only
agree
whether
with you,
there's
Judge.
misconduct matters.
I fully agree with you.
What was the Palmieri statement introduced to establish that Ms. Hinkes in fact acted in an unprofessional manner? Or was it used to establish what Reddy knew before terminating her, including complaints of unprofessional conduct?
It was
in
not.
cons-
I'm sorry,
with
Judge.
her behavior by Oracle persons.
It was not offered for the truth, and the arbitrator took his time to make sure he was clear on that and question the witness himself. It was not offered for the truth of the matter asserted. It was not offered to prove that she engaged in misconduct. It was offered to prove the effect on the Oracle client, which is relevant because she was hired to service this Oracle client as part of her main job responsibility.
And do you agree or disagree that the arbitrator didn't mention her Palmieri's statement regarding Ms. Hinks in discussing the basis for the termination decision?
I agree with that completely, and the district court, Judge Hunt, found the same. Sunera's principal, Mr. Reddy, testified, and the arbitrator found, and Judge Hunt found, that Hinkes' justifiable non-discriminatory termination was not based on Palmieri's statement. Instead, it was based on, quote, ample and mounting evidence of just and sufficient cause for termination that included failing to book a single penny of revenue, which is a problem for a sales representative, and it's a violation of her contract. Insubordination to her employer, she incurred massive expenses that exceeded her salary at Sunera, and for failure to achieve a technical certification that she needed to perform her job, various and sundry other reasons that are listed in the briefing and the arbitrator's decision, Judge.
And is it so that she only worked at Sunera for 5 months?
That's correct. She only worked at Sunera for 5 months.
So your point is that, yeah, what happened in the deposition testimony happened in the deposition testimony. We can read it and see it, but it had nothing to do with the ultimate decision.
Absolutely. And that is absolutely what District Court Judge Hunt found when she confirmed this arbitration award, Judge. Hinkes also advances on appeal an argument that the arbitration decision should be vacated because we introduced 2 exhibits, 3 pages of documents to impeach her and or refresh her recollection as to whether she received the employee handbook.
Had she submitted any discovery requests that sought such documents or for which such documents were relevant and should have been produced?
She submitted discovery requests, Your Honor, and the arbitrator actually invited, and this is in my brief, the arbitrator invited Hinkes' counsel to point out the specific request to which she contended the document should have been produced. She was given that invitation and she never took him up on it.
You should face the bench when you're
I apologize.
answering. Judge Rovner is not in the screen.
Yes.
She will actually see you best if you face the camera.
Thank you.
Thank you. I'm sorry. I wish I were where you are.
So Sunera was, of course, entitled at the arbitration to impeach Hinkes' incorrect testimony that she had not received the employee handbook and to refresh her recollection that she had, in fact, received the employee handbook and reviewed all the policies. So here again, the argument advanced by Ms. Hinkes on appeal is specious and frivolous. Hinkes has not advanced a single colorable ground for her appeal and request for relief in this court. Her appeal is not supported by a single opinion of the circuit or any other. She cites various cases from other circuits that are decades old. There is
That
simply
doesn't make them wrong.
there's simply no legal foundation for her claims and for her appeal in this court. and Sunera requests that the court affirm the district court's well-reasoned decision confirming the arbitration award in favor of defendants. Thank you.
Thank you very much. The court directs the parties to file supplemental memoranda within 14 days addressing the question whether the court has subject matter jurisdiction. The memos should address both Section 1653 and Newman Green against Alfonso Lorraine. When they have been received, the court will take the case under advisement. Our next case is United States against Frazier. Mr. Hammernick.
Good morning, Your Honors, and may it please the Court. Jared Hammernick for Matthew Frazier. I'm going to do my best to reserve about 2 minutes for rebuttal. And subject to the Court's questions, I intend to focus my time on the first issue in this case. When Mr. Frazier told the judge that he was seeing about 100 dead people in the courtroom and confirmed that his medication had recently changed, and then also said that those voices were getting in the way of his ability to understand what was going on, he also confirmed that those voices wanted him to hurt people, there was reasonable cause to believe that Mr. Frazier may be mentally incompetent. Because there was reasonable cause, Section 4241A required the judge to inquire sua sponte into Mr. Frazier's competence. Because the judge didn't do that, we think the judge abused his discretion.
But didn't the prior competency determination recognize that he had ongoing auditory visual hallucinations, but conclude that the symptoms did not appear to be impacting his ability to understand and rationally apply facts that were related to the legal process in his case? And I mean, were there any other indications that he was not competent at the time of his trial and sentencing? Or, or is the only reason to question it, his competency, that is, the statement regarding his auditory and visual hallucinations at the waiver of the jury trial?
So that's right. We have focused this appeal on the jury waiver hearing the morning of April 9th, 2024, when he had this conversation about these violent hallucinations. So we're not saying that there's something in the record at trial or at sentencing that independently gives rise to reasonable cause. We think it's this hearing combined with the other objective indications of potential incompetence that exist in the record. Coming to your specific question, Judge Roedner, yes, there was this year-old competency finding. We think it's expressly contingent, and it uses words like he's currently competent, he was competent at the time, his symptoms were well managed by medication. But that medication had changed, and we know it had changed recently at the time of the jury waiver hearing because he said so. And it's true that he had these auditory and visual hallucinations even a year prior, but there was this obvious escalation, or at least an escalation that seems obvious to us in the symptomology. He now is being told by these hallucinations to hurt other people. We think that's an escalation that, combined with his prior finding of incompetency, his long history of mental health problems, and
don't you think the district court? The district court recognized the gravity of what it had on its hands in front of it. I mean, everything that you're saying, and you've done a good job in your brief, is super serious. But the district court really caught that.
Yeah.
Did it not?
No doubt.
Yeah, and so the district court was aware of this obligation, was aware of what he was being told, the district judge in the courtroom. And you're right that it's extreme, it's serious. You'd have serious questions about competency if a defendant was telling you things like that in the courtroom. But the district court was the one that really understood that. So what I have a difficult time with is, where's the error here?
Sure. So the legal error is skipping to step 2 of the 4241A process, right? So there are serious concerns. I think we can all agree on that. And that's what under 4241A triggers the evaluation and the hearing, right? So the bottom line finding of competency, which is the one I think the judge made, that the legal error was skipping to step 2 of the 4241 analysis without getting evidence and experts involved, right? The point of the hearing is to determine
But wasn't
competency.
the district court mindful of the road that everything had traveled?
Yes, absolutely. But I think what the judge did not take into account was the escalation in symptomology at this hearing, right? So he certainly grappled with it, and the conclusion was that he's competent. But that's not the question the statute directs the court to ask in the first place. The first question is there reasonable cause to believe that he might not be? If there is, you get evidence and experts involved, and then Mr. Frazier may or may not be able to prove his actual incompetency, but he doesn't have to prove actual incompetency to get a competency hearing. And so the legal error is in skipping to step 2 of this 4241 analysis.
So we shouldn't take into consideration the fact that his attorney, who had sought the first competency hearing, believed that his decision making was at the same level as when the prior competency determination was made, and believed him competent, and believed that he understood what he was waiving. Of course, he himself indicated that his mental health was the same as it had been. And I really commend Judge Leidy in every possible way for the way he questioned him. You know, having him explain the concepts in his own words. So he was ensuring that he wasn't simply responding rotely and exploring the legal rationale, for the waiver. So, yeah.
So that's right. What I hear in your question is, how can it be an abuse of discretion if his own attorney didn't ask for a competency evaluation, even though the attorney previously had? If I've misunderstood your question, please correct me.
Well, plus how carefully the judge was
Certainly.
in trying to make certain.
Yeah, so I think that's right. So let me take the second part first, which is there's no doubt that Judge Lichty was careful in this case. I don't have any dispute with that. I think the difficulty is that, in cases like Graves, this court has said you can't just sort of skip past reasonable cause if you think there are other countervailing indicators, if there are other things to think, well, maybe he is competent, maybe he's not competent. That's why you need the hearing. That's why the statute sets out this two-part process.
You're basically saying, my words, not yours, but I hear you to be saying, given the extreme nature of what the defendant was reporting seeing in the courtroom, there had to be a bookmark put on the proceedings. We had to have a fresh, present tense inquiry into his competency. And then and only then can we go. That's your argument.
Yeah, I think that's exactly right. That is the argument. And to the extent that
Can you help me out on this business I've been confused about this whole medication business.
Sure.
Okay. You make the argument, I think, correct me if I'm wrong, that the defendant was of the view that his hallucinations may, worsened or something, intensified because he changed medications?
So it's not clear to me, actually, whether they worsened because of the change or because they're just in this sort of, ramp-up period on a new drug, right? These are some of the most
Is it the new drug being Zyprexa?
I believe that's right, yeah.
Okay,
Yeah.
and the old drug being Invega?
Yes.
Okay, what do you understand the argument to be as you stand there right now?
Right, so I understand what the argument to be. A change in psychotropic medication is something that has profound effects on the brain and can cause, either in the interim or because of a worse reaction to the new drug, can cause worse symptoms. So I don't think that we know based on this record whether.
Okay, and is it your understanding that defense counsel, it wouldn't be the defendant himself, I don't think, but maybe it was. The defense counsel said, hey, Judge, there's a change of drugs here that could account for the change from last year to this year.
Sure. So defense counsel didn't make that point below. Mr. Frazier himself actually pointed this out to the judge, that he had, I believe the testimony was a few weeks prior, he had changed the drugs that he was taking, that Zyprexa was no longer available. That's what the jail's pharmacist told him, and so he had recently undergone a change in the drugs. We don't know exactly what impact that had, but I think, again, that's why the evaluation and the hearing is necessary to ferret out that sort of evidence. Seeing that we've got about a minute left, if you don't mind. No further questions?
If we can give Mr. Hammernick that extra minute, I do have a question. I don't want to take up his time, but I do have a question.
It's your time. Don't mind.
Thank you. Can the supervised release
Counsel, if you would face the bench, you will also be facing Judge Rovner. She is not
Aye.
physically in that screen.
I apologize.
I will be next time. Can the supervised release condition be satisfied by 10 hours of community service weekly? Is there any indication in the record that the district court believed Fraser to be incapable of that level of organized activity?
Not to my knowledge. I don't think there's anything in the record where the court or the district judge said, hey, you know what, I'm giving you a 30-hour per week full-time employment requirement, but short of that, do 10 hours a week of community service. I think that sort of clarification by the judge would have justified that condition, but there's no finding along those lines. So, you know, we think that this basically is an exceptionless full-time employment condition. And yes, buried within it, you have what looks to be a backstop of a community service requirement. If the judge really meant to impose a community service requirement, we would just ask for a remand so the judge could clarify that. But a full-time work requirement, we think, is plainly inappropriate given the court's repeated findings that he can't work.
Thank you.
Thank you, counsel. Mr. Whalen.
May it please the court. Thank you, Your Honors. Nathaniel Whalen here on behalf of the United States of America. The district court did not abuse its discretion by failing to sua sponte order a second competency evaluation, nor did it plainly err in imposing the condition of supervision that's challenged on appeal, and so we ask you to affirm his conviction and sentence. I think Your Honors have hit the nail largely on the head here. What we have is a situation where a defendant went for a competency evaluation, and he said during those times that he's hearing voices, seeing people that aren't there. He says that on multiple occasions in the competency evaluation, and in spite of that, the two doctors at the MCC determined that he was competent. This is a very different case if that competency evaluation never takes place. Because what Judge Lichty also says during the waiver of the jury trial colloquy is that he has that report literally sitting with him on the bench while he's reviewing this waiver. He's well aware of its findings. And so he understood that this is a static condition that the defendant appears to be under, that he is hearing voices. And Judge Rovner, to your point, he doesn't just accept it, right? He doesn't say that, yes, you're hearing voices. And
Judge Rovner is not in the screen. Face the camera.
I apologize, Your Honor. He does not at any point say that just because he's hearing voices, that's the end of the analysis. What he does is he engages in a lengthy colloquy where he asks the defendant over and over again questions to ensure the defendant's competency. And he does ask the defendant, have you changed medication? Judge Scudder, to your point, so on page 5 of the colloquy, he says that he's no longer taking Seroquel. Seroquel was the one he took during the MCC evaluation, and that's on page 10 of the psych eval report. On page 5 of the colloquy, he says he can't get Seroquel anymore. Instead, what he gets is something called Zyprexa. They're both dealing with mental health illnesses like schizophrenia, manic behavior, bipolar behavior. That's the switch. But what he also says is, yeah, and I was also hearing voices when I was on the prior one, and that wasn't working either. So even though there is a change in the medication, what we have is the same symptoms that are in front of Judge Lichty as he's undergoing this evaluation as previously existed at the MCC. What the court did is what this court's told this district court judges to do and engage in this colloquy. He asked Mr. Frazier to define a jury, or he didn't ask, Mr. Frazier voluntarily defined a jury for the district court. He defined what unanimous meant. He told the court he understood concepts of jury trial and sentencing and a waiver of a jury trial. He stopped and he asked questions when he didn't know the answer to things. He consulted with defense counsel. And yes, he had a mental illness. I don't think that's a dispute at this point. But mental illness is different than incompetency. And the competency had already been evaluated. There's no reasonable cause to engage in a separate competency evaluation when we have the same symptoms here. Now, I understand Mr. Frazier's position is that there's an obvious escalation in symptomology. I'm not sure that that's correct. I don't know that at any point the mental evaluation from the MCC was based on the number of individuals he's hearing or the content, right? I don't know that someone's more or less competent if the voices he's hearing says hi or you should hurt someone. That might affect his mental illness, but it doesn't affect his competency. And so when Judge Lichty hears that, he does go step by step and say, you know, where are these individuals in the courtroom you're hearing? Can you hear me? Can you tune everything out? And then he asks question after question to ensure that Mr. Frazier is in fact able to hear Judge Lichty and engage in a colloquy with him. That's what you want the court to do. What the court also did was it asked defense counsel, has anything changed? And as Judge Rovner pointed out, nothing had changed. Defense counsel said he has the same rational thought process as he did when he was previously sent for an evaluation. And so defense counsel, who this court heavily defers to because they are the individual that is engaging with the defendant on a regular basis, says nothing has changed. Does not trigger any obligation for Judge Lichty to sua sponte, stop everything and say we need a new mental health evaluation. Finally, the court, I apologize, Your Honor.
At sentencing, the district court declared that idle hands can be evil hands. And that can prove true once again on supervision, because the unfortunate reality is you can't work because of your ongoing disability. And the court also declined to impose an assessment because his disability meant he did not have an earning capability. Isn't that language inconsistent with a supervised release requirement of full-time employment? And at a minimum, shouldn't we require the court to reconcile those apparently contradictory statements?
I don't think it is inconsistent, Your Honor. I think what the court was trying to get at is this defendant needs to do something, right? This defendant needs to not have idle hands, because when he commits the incident offense, he's on probation from his prior conviction, essentially in his bedroom trolling the internet and finding child pornography. Now, we have a much harder case if this is like Capus or some of the other cases the defendant cites where there is no backstop about community service and job skills training program. Reading the condition at paragraph 100 in the PSR, the backstop is absolutely in there. There's a work condition, and it says, if you are not employed, you must try to find full-time employment. If you become employed, you have to tell your probation officer. If after 90 days you do not find employment, you must complete at least 10 hours of community service per week until employed, or participate in a job skills training program approved and directed by your probation officer. So if the district court had said you need to work full-time, that's a tough argument for us on this record. The district court didn't say that. The district court said you need to work full-time, or if you can't do that, community service or job training.
So are you trying to reconcile what I believe to be contradictions by reading the supervised release condition as merely a requirement of 10 hours per week of community service? I mean, is there anything in the record indicating that this fellow, Fraser, who the district court noted had been disabled since 2001, would be capable of 10 hours per week community service?
I don't think there's anything in the record suggesting the defendant couldn't engage in 10 hours of community service. And because we are here on plain error standard of review, it's not plain and obvious he cannot engage in those 10 hours. And he's never argued that. He's never taken the position that he can't do 10 hours of community service or work training program. So it's not plainly and obvious erroneous to impose this condition as stated in paragraph 100 of the PSR.
So is what you're saying, Mr. Whalen, that no, the government is not going to hold him to employment if he can't work. He hasn't worked forever. But if he, we are going to hold him to at least trying the 10 hours of community service upon release, and if there's still an outlet if he can't do that. If his mental illness, prevents him from doing that, he can file an application at that point in time to modify the supervised release and just terminate the condition altogether.
He could, Your Honor. The government's not going to hold him to anything. The probation department's going to hold him.
No, that's what I mean.
I apologize, but what the condition is saying is that he should work full time because he needs to have some pro-social behavior. Right. He needs to have some public protection. He needs to rehabilitate. And yes, if he is unable to find employment at that point, this condition provides a backstop.
Yeah, do community service
correct.
Or job training.
Correct, and that's the type of condition that this court has affirmed prior. And
if there's a application to the court that he's violated his supervised release because he's not working, the parties will end up in front of the court, and the district court judge will hash this out because he can say, I'm not working because I can't work.
Well, that's correct, Your Honor, but I think a violation would have to occur if he can't work, and then if he's not engaging in community service, if he's not engaging in the job skills. That's correct, Your Honor. Unless this court has any questions, one note about the condition itself. The defense says that the district court didn't adopt the reasoning in the PSR. That's not correct. On page 18 of the sentencing transcript, the district court says your supervision will be governed by the recommended conditions for the reasons that are stated in that report as well as stated by the court today. So the court's adopting this italic part on paragraph 100 of the PSR that is additional support for its reasoning in imposing the condition. Unless this court has any questions about the condition of supervision or the competency evaluation, we would ask you affirm. Thank you.
Thank you, counsel. The case is taken under advisement. Case number 5 for argument this morning is Talley against Globe. Mr. Howell.
Good morning, and may it please the court. Isaac Kittle on behalf of the plaintiff appellant Randy Talley. The first step in evaluating a pretrial detainee's failure to protect claim is determining whether a reasonable officer in the defendant's position would have put the puzzle pieces together about the risk of harm to the inmate. And an inmate puts a reasonable corrections officer on notice of impending harm by producing a specific complaint identifying the prospective assailant, a credible complaint, and a complaint that identifies an immediate and serious risk of harm. And I think here it's clear that Mr. Talley satisfies those requirements. He makes a specific complaint to Deputy Talley, identifying Mr. Wheeler as the prospective assailant, and he identifies specific conduct as well, identifying that Mr. Wheeler had just attempted to assault him without provocation. I think it's a credible complaint because Deputy Glody hears a commotion coming from the cell block which houses Mr. Talley, and Mr. Wheeler. And when he arrives at the cell block, it's confirmed that this commotion is coming from their cell block because these two individuals are continuing to act animated, in his own words, boisterously, yelling over one another, at which point Mr. Talley presents this specific claim that Mr. Wheeler just attempted to assault him. And I think that it's an imminent risk of harm as well, particularly given the layout of the cell block where Mr. Talley is housed at the time. This isn't a situation where they're out in general population and they have plenty of room to roam around. They're in an 8-cell block with Talley and Wheeler's cell housed right next to one another, adjacent to one another. And so when Deputy Glody hears the report from Mr. Wheeler and Mr. Talley about the altercation that just ensued, these two individuals are actually somewhat separated. There's a corridor blocking the two. And, Mr. Wheeler is standing in the doorway and he's talking to Deputy Glody. There's a wall separating them. And then Mr. Talley is talking to Deputy Glody at the same time through a window. So, and I think that takes us to the analysis here of objective reasonableness, where these two somewhat separated individuals are now ordered to go back right to the situation where the assault occurred, which I think directly puts Mr. Talley in harm's way. Not only because of the opportunity that Mr. Wheeler had to assault him again as he's walking back, but I think that Mr. Wheeler, it was foreseeable that he now had unfettered access to Mr. Talley as he entered his cell. And that's where I think
what's the constitutional violation? Go ahead.
I'm sorry, when they returned to their cells, Talley walked in front with Wheeler walking behind him. Did they have a choice in the order in which they walked?
I don't believe there was a choice in it, and I think it was a simultaneous, in order for them to lock down simultaneously. And that, I think, exactly speaks to the unreasonableness of the order, because I believe there were reasonable measures available to abate the risk of harm, the clearest one being that Deputy Glode should have ordered them to lock down one at a time, which would have gave Mr. Talley an opportunity to safely get to his cell and then lock down, which I think it's a key component of locking down, is not just the end result of safely closing your jail cell, but also walking to your jail cell and having the opportunity to close the jail cell before Mr. Wheeler would have an opportunity to then walk back. And I think here when we're looking at the analysis of objective reasonableness, it just can't be said that when an officer gives an order that puts an inmate directly in harm's way through his order, making it more foreseeable that he would be put in harm's way, that can be reasonable under the constitutional standard here being the 14th Amendment. He's a pretrial detainee, and so we're working with a less stringent standard here than under the 8th Amendment, which is cruel and unusual punishment, whereas here he's still subject to the presumption of innocence, and he's subject to a standard that he's not entitled to be punished whatsoever. And so rather than requiring a deliberate indifference analysis here, we're just looking at objective reasonableness. So the specific facts and circumstances available to a reasonable officer in Deputy Glody's position here. And I think it was clear to a reasonable officer in his position, based on the information available to him with the specific complaint, which I think is credible and it presents the imminent risk of harm, that there were other reasonable measures he could have taken to abate that risk of harm. If there are no other questions, I'd like to save my time for rebuttal.
Mm-hmm. Certainly, counsel. Mr. Procopio.
Good morning, Your Honors. Attorney Greg Procopio on behalf of the appellees Carl Glady and Dane County, and I just first like to say it's an honor arguing before you guys today, for the court today, I'm sorry. May it please the court, this case ultimately turns on whether Deputy Glady's decision was reasonable in the moment with all the information he had. I agree with my friend on the other side that the court needs to take into account the entire puzzle, all the pieces. If we look at the undisputed facts, it was certainly reasonable for Deputy Glady to order both Talley and Wheeler to lock down. First, Deputy Glady heard general yelling, a commotion coming from the area where Talley and Wheeler were housed, cell block 607. It was only when he approached the cell block that he realized it was coming specifically from 607. And when he approached the cell block, Talley was at one window, Wheeler was separated at another. Deputy Glady approaches Mr. Talley first and says, "What's going on?" The only information in the record is
staying outside the cell block. I mean, remember we have a video of this.
Yes.
Right. So he never enters the confines of the unit. He stays outside and talks through the glass window or whatever, the vent or whatever it is.
Deputy Glady, yes, absolutely, Your Honor.
Right.
And the only information related to Deputy Glady at that time by Talley was, this guy's crazy. He tried to steal, he says I stole his minutes. He tried to take a swing at me. That's all. Then Deputy Glady, trying to gather as much information as possible, goes over to speak to Wheeler. Wheeler is simultaneously accusing Talley of theft. They're accusing each other of two separate things. At the point Deputy Glady is speaking to Wheeler separately at the window, Talley walks over to him. Talley doesn't go into his cell. Talley doesn't continue to stay separated at the window. He walks directly behind Wheeler. And as Talley testified in his deposition, he's trying to continue to explain the situation. So at this point, Deputy Glady is confronted with two inmates accusing each other of different things. There is no signs that their verbal dispute had escalated, because it hadn't. Wheeler actually never touched Talley. So the assault, my friend says, never actually occurred up to this point.
If Wheeler had made contact with Talley's face when he first took a swing at Talley, would the perception of the risk posed to Talley by Wheeler be any different?
Likely not, Your Honor, because Deputy Glady would not have witnessed it. However, if there were signs, there was more evidence. Say if Wheeler struck Talley and Talley was bleeding, he had a bloody nose or a bloody lip or a bruised eye, and Deputy Glady and Talley was like, "Look, I'm bleeding. My nose is broken." then possibly, but because Glady never witnessed any of this, I don't think it does, Your Honor. So back to the totality.
So I think the only, just in the interest, I think the only possible constitutional argument is that he should have immediately called for backup, because our case law is pretty clear that he doesn't have to enter the actual cell block area. Because what if it's a ruse?
Yes, absolutely.
What if
Your
the
Honor.
argument is a ruse?
Absolutely. It's a ruse in order to get the deputy
To draw
come
him in, and then
Yes.
they beat him. So the only claim here seems to me to be, in the circumstances that he confronted, that Mr. Talley would argue, that he had to have immediately called for backup. Because he's not going to go in there alone.
Sure.
And then the question is, were those circumstances such? And all you have here, you have two people, prisoners argue about all kinds of things. You have two people arguing about access to the iPad, or who's got what minutes on the iPad or
Yes.
something, right? Why does that present a circumstance where you think somebody's going to be beaten down in their cell momentarily?
It doesn't, Your Honor. Plain and simple. There's nothing in the case law that would require Glady to make an immediate decision, because again, it's the totality of the circumstances. Nothing presented in front of Glady would have required him to call immediately for backup. The inmates were already separated, and they initially complied with
And
his
the
order.
content of what the complaint was matters too. It's right, it's not that Mr. Wheeler just tried to stab me with a shank, or he just tried to hit me with a chair, or something like that. It's that we're arguing about the iPad.
Yes, and the alleged swing. That's all.
The alleged what?
Swing.
Oh, all right.
That's all.
Okay.
And for the same reasons why Deputy Glady's actions weren't unreasonable under the totality of circumstances are the same reasons why Deputy Glady couldn't have appreciated the risk of harm to Talley.
Can I ask you a very random question just before you sit down, before you go back? What is a probation hold? Is that where you're in the jail because you may have committed a probation violation and they're trying to get that sorted out?
Yes, Your Honor.
Okay.
And Talley was on a probation hold at the time.
All right.
If there are no further questions from Your Honors, I yield the remainder of my time, and I just ask that this court affirm the district court's ruling. Thank you for your time, Your Honors.
Thank you. Counsel, anything further?
Nothing further, Your Honor.
Pardon?
Nothing further.
Okay. The case is taken under advisement. The court will now take a brief recess before calling its final case. ready now for our final case of the morning, Cisneros against Nuance Communications. Mr. Wise.
May it please the court, my name is Brandon Wise and I represent plaintiff appellant Norma Cisneros. Today we ask the court to reverse and remand this matter as the lower court erred in granting a Rule 12b6 dismissal of the case based on BIPA's 25C exemption for financial institutions, as that term is subject to the Gramm-Leach-Bliley Act. We believe that the district court erred in its interpretation of the Gramm-Leach-Bliley Act, which defines a financial institution under Section 68093A by incorporating activities that are set forth in the Bank Companies Holding Act.
Counsel, let me get straight to my major worry about this case. Let's assume that you're right, that Nuance can't be treated as a financial institution itself. My question is, how can you prevail without requiring Schwab to do something? And you concede that Schwab is a financial institution. It's Schwab that has hired Nuance to do particular things. It's Schwab with whom the customers contact. And Schwab can't be required to comply with this state law. So how can you get anywhere in this case?
So I think we do, for the record, concede that Schwab is a financial holding company and therefore subject to Gramm-Leach-Bliley. The difference is, especially looking at the different sections of BIPA, there are different requirements, one of which is 14/15A, which would only require Nuance, not Schwab, to make publicly available postings regarding
and which we have held cannot be enforced in federal court because the plaintiffs lack standing to enforce sub 15 sub A. So if your answer to my question is it's because we rely on sub A, you now have an Article 3 problem, which you need to address.
Yeah, that's my question for you. Is there Article 3 standing on the 15A claim?
I think there is. I think there are multiple courts that hold on the basis of something like unlawful retention of biometrics, in addition to other types of violations of.
Yeah, don't worry about other courts for a minute.
Sure.
Okay. I mean, you can go back to other courts. Can you just focus on what allegations in the first amended complaint allege harm, injury in fact, actual or imminent, that would give your client standing on the 15A claim? Right, all I'm doing is trying to summarize the standing test for you.
Sure. No, I think that in the first amended complaint, we outline our 15A claim.
No question. There's no doubt about that. The question is what actual harm is alleged to have followed from forget 15B, 15A.
I suppose the 15A claim would be the failure to implement a 15A policy and to abide by it.
We have expressly held that failure to implement a policy under 15A is not a source of standing. We have, let's just say, wavered on the question whether the retention schedule can itself be the source of standing. But
I agree.
What allegations are you making that show the kind of harm that would pass muster under our decisions?
Yeah, that's the question. It's not a matter of do we understand 15A? We understand it. You understand it. The question is what harm is alleged in connection with 15A.
And again, I believe that Seventh Circuit precedent has held that.
Don't worry about Seventh Circuit precedent. What's in the complaint? You might want to go on.
So the complaint, I guess, subject to 15A, that we've alleged that defendant has failed to abide by a policy.
That is not sufficient for standing. We have held over and over and over that just failing to abide by the law does not produce standing. What's necessary to standing is injury in fact, traceable to the defendant's behavior and redressable by the court. We're asking you questions about injury.
And so the injury wouldn't be the failure to abide by the law. It would be the failure to abide by Nuance's own policy, which it did not create, I guess.
It's not.
I also
that
think
is not injury, right? The Supreme Court has held, and as I say, we have held over and over and over, that not following the law is not enough for standing. So how does your complaint allege injury?
I think
Injury
we
in
also
fact.
allege injury under Section 1415B. And going,
That is something that is on Schwab's tab or not.
and
You really need to concentrate on the question you're being asked.
I think that there are ways that nuance that are not related to Schwab in relation to Section 1415B. Whether or not nuance is collecting biometric information such that it would be in violation of BIPA does not relate to, is not necessarily implicating any action on behalf of Schwab. Whether or not as a business-to-business relationship.
Yeah, here's the problem. I'm going to try one more time.
Okay.
Okay. What you're relying upon, I think, is paragraph 97 of the First Amended Complaint. You may be relying upon it because it might be the best you can do. Okay, where you say the defendant fails to comply with these BIPA mandates. That's basically saying the defendant fails to comply with law. And what you have two members of the panel asking you is, yeah, we read it, we see it. It's not, we get it, okay? What is the injury? You're not injured in an Article 3 standing sense by a defendant's failure to comply with law without more. And the question is, what more is there in the First Amended Complaint?
Judge, I'm looking to how the district court assured itself that it was, that there
Yeah,
was.
you might want to use your rebuttal. Think about it
standing.
before you come up with rebuttal. I mean, I'm mindful that your time is running.
Thank you. The question before that was, I believe, how does this case not implicitly regulate Schwab? And I do think that some of that turns on the requirements of Section 14B. And that's where there are a number of requirements that private entities who collect biometrics must perform, including getting written consent. But the district court did correctly hold that nothing in the complaint, especially at the motion to dismiss stage, where Section 25C would function more as an affirmative defense, has to be read in light or can be read in light of necessarily requiring Schwab to take actions such that Section 25C should apply under a theory of indirect application.
Could you be concrete? What action was Schwab required to take by the state law that you say it hasn't taken, given that Schwab is exempt from the state law?
I don't believe that Schwab has to take any action specifically
so
because
we're
it's
not
exempt.
looking at Schwab.
Correct.
Yeah, see what's happening is if we're not looking at Schwab, we're looking at nuance. We got to focus on how's nuance harmed. If you can't focus on Schwab, Schwab can't impose harm, right? Where's this coming from?
The only thing nuance has done is to collect data, which it receives via Schwab, and retain it and not disclose its retention policy. And we've been asking how those things harm the plaintiff. And so far, I don't think you've seen what the problem is.
So I think under Section 14B, the failure to obtain the written, the collection of data.
15B.
1415B of
Okay.
BIPA. The collection of data without informed consent does give rise to a tangible harm.
You have to show harm. A violation of law is not harm. It may lead to harm, and if it leads to harm, it may be actionable. But a violation of law is not itself harm. I think you're just
Maybe I'm missing
trouble with that basic point.
Sure, and I think I'm trying to square the question with cases like the Seventh Circuit's Compass Group case, where it found that Section 1415B, when a plaintiff's biometric information is captured without consent, that is a traditional privacy-related harm that the court has found provides subject matter jurisdiction. I'm sorry, I'm completely
is the
missing.
person who either does or doesn't get consent, and you've agreed that Schwab is not covered by the state law at all.
And I think that is the basis of our case, that Nuance had an independent duty to obtain consent.
Why? What in the state law requires Nuance to obtain consent when it's Schwab who deals with the customer?
The law, BIPA is agnostic whether or not it's
Let's suppose
directly the
Schwab
customer.
gathers this data and sends it straight to the KGB. Well, it's now no longer the KGB, but you get the idea. What in the law required the KGB to obtain anybody's consent? Because the KGB didn't deal with the plaintiffs. Only Schwab dealt with the plaintiffs.
I think that the statutory text of BIPA is agnostic as to whether or not you are direct. There's no relationship or customer requirement. It is the act of having the biometric data in your possession.
So you think that the KGB would be in violation of Illinois law?
If they
Is that remotely plausible? It's not something you want to stake your case on.
So
you seem to be relying on retention in part. What's your best case after TransUnion that the mere retention would be an injury in fact?
So I think after TransUnion, it's, and maybe I'm ineloquent in retention, but they had to collect the data at some point. And collection or taking of data without consent has been recognized in numerous cases post-TransUnion as a traditionally recognized type of harm.
But it's Schwab that collects the data and sends it to Nuance.
And so I think that oversimplifies what we have pled in the complaint, because I think that there's no fact.
It does indeed oversimplify. Between Schwab and Nuance, there are a bunch of actors on the internet, right? Maybe Amazon Data Services.
Sure.
Has Amazon Data Services violated this law by not getting the plaintiff's consent before it transmits the data through its data centers to Nuance?
Yes. And I actually think that...
You realize how many actors there are on the internet between Nuance and Schwab. There could be thousands, and you think they've all violated this Illinois statute?
I think that if, on the basis of what's alleged in the complaint, when someone calls in to Schwab, if it is Nuance that first receives their biometric information, whether or not Schwab
No, it's not.
disclosing...
Nuance is not the first recipient. You're not understanding my question. The first recipient will be the internet service provider for Schwab, which transmits it to another. The internet can have thousands of links. It may go through a data center at Amazon Data Services, which may actually be where it resides, but in the control of Nuance. I asked you whether you think that all of these entities, right, the internet service provider may be AT&T. Is it violating the statute?
If AT&T would be collecting plaintiff's biometric information...
No, Schwab collects it. It then moves through a series of steps over thousands of different wires, goes up to satellites that are run by still other companies, comes back down. Are they all violating this statute?
I think that the text of BIPA is agnostic as to whether or not there's a customer relationship. BIPA applies to private entities who are in possession of biometric information.
Do you have any state case suggesting that Amazon Data Services or AT&T violates this statute by not having and disclosing a data retention policy?
I know that there are cases against companies like Amazon. I'm not sure about AT&T, but I think one analog that's very important is in the timekeeping context. There are cases against the time clock vendor who has no relationship with the employee who was using the biometric time clock. That's the same type of relationship where there is actually no relationship between the person
Okay,
clocking.
I think we have your position, counsel.
Thank you, Your Honors.
Ms. Kostanek.
Thank you, and may it please the court. As your Honor's questions reflect, I do think that plaintiff is in quite a double bind here. We do believe that plaintiffs have limited Article 3 standing to the following extent. So paragraphs 37 through 39 allege that while Schwab offers voice ID, in the course of which it collects the plaintiff's voice prints, Nuance stores that voice print. So there are two claims in the complaint, and it seems like there's no dispute about standing for the 15B claim. So focusing on the 15A claim, the plaintiff alleges then in paragraphs, as Judge Scudder noted, paragraphs 96 and 97.
Look, counsel, the complaint alleges that Schwab stores the data. That's probably wrong. It's probably Amazon Web Services who stores the data in an account for which Schwab pays. But put that to one side. How does that part of the complaint allege injury in fact?
Yes, Your Honor. I understand this court's opinion in Fox to hold that the allegations, not just that that Nuance has or does not have a written policy, but that it doesn't act pursuant to that policy to delete retained data constitutes an injury in fact. So the
How is it an injury in fact?
Well, I understand this court's analysis in Fox
just
to say that
as Judge Scudder said, forget about your understanding of this court's analysis. Can you explain in your own words why you think that that is an injury in fact?
The allegations of retaining data beyond a period of time that's allowed and promising to delete that data is akin to an invasion of privacy cause of action.
That doesn't sound... Look, retaining something is not the invasion of privacy. Getting something might be. But an invasion of privacy, if I get a secret fact about you and I never tell anybody, I've retained it in my memory and not purged it from my memory. The getting of it may be a legal wrong, but my retaining it in my head is not a legal wrong. There might be some harm alleged, but it being in my head is not such a harm. I'm trying to figure out why there is such a harm here.
And I hate to take you back to the case law, but what a quote from this court's opinion in Fox is, the unlawful retention of biometric data inflicts a privacy injury in the same way that actual collection does. And the analogy was to the tort of trespass or an invasion of privacy tort. And so to the extent that the question is...
So you think if I know a fact about you and I remember it for the rest of my life, I'm violating your rights for the rest of my life because you were injured for the rest of your life?
I think that it creates the risk that there is...
Now that's what we've actually talked about. There is a risk of wrongful disclosure, right? So it would be interesting to know some facts about that risk. The complaint doesn't seem to have any.
There is one paragraph in the complaint where the plaintiff talks about the risk of hacking.
Yeah, anybody can use the word risk. Is this real or is it a phantasm?
I understand, Your Honor. And to the extent that there is a question about whether the plaintiff's allegations of risk here rise to the level that is cognizable post-TransUnion, I'm not sure that this court has addressed it. We would ask for the opportunity to do supplemental briefing on it to be able to analyze for this court to the extent it's helpful as to whether it's something that is analogous to a common law tort. We do believe that on turning to the merits, that the case does present a pretty straightforward question of statutory interpretation, that to the extent that the plaintiff does have standing, it is for violations that require Schwab to take action. So I'll start with that alternative ground for affirmance that Your Honors were talking to my friend on the other side about.
I think we're past that. Your adversary agreed that the plaintiff is not asking for anything that would require Schwab to act.
But they say otherwise, Your Honor. They specifically allege in the complaint that
I think we're past that. You heard Mr. Wise on his feet say they're not asking for anything that would require Schwab to act.
But the complaint controls, Your Honor. So
that's completely wrong. Lawyers can give up allegations in the complaint. We are here in light of the arguments being presented to us. The arguments presented long ago in the complaint do not prevent the plaintiff from saying, we are no longer arguing X.
And the reason why I'm taking you back to that is because it just shows that there's no workable way in order to impose BIPA obligations on Nuance without also imposing them on Schwab. But maybe I'll take the district court's analysis here and the primary ground for affirmance then, which is that BIPA exempts from its scope a company like Nuance here that provides...
I must say, I cannot see how Nuance itself could possibly be exempt. You have a ruling by the Fed that Schwab can deal with Nuance. Fine. How does that make Nuance a financial institution? Schwab can deal with Amazon. I'm sure Schwab buys office equipment from Office Depot. Is Office Depot a financial institution?
It is not, Your Honor, but that's because it doesn't fall within this clear set of statutory cross-references. So first, BIPA has
I hate to tell you, but the Fed's regulations allow financial institutions to engage in the normal transactions of that business. And your argument is that by engaging in one particular kind of authorized transaction, that made the other party a financial institution too, which would equally apply to office supplies and cars and computers and...
I disagree wholeheartedly with that, Your Honor. So the Fed's order in question here, the one from 1999, is not actually about the bank engaging in a transaction and authorizing the bank to engage in authentication services. It's actually about a joint venture called Indentris in which the bank wanted to maintain a voting interest. And so the question before the Fed was, can there be a voting interest in a joint venture that engages in authentication services? And what the Fed held was, yes, it is closely related to and therefore properly incident to banking. And to the extent it provides authentication services to a bank, that we consider that to be financial activity. The GLBA specifically adopts orders of the FRB that predate the GLBA, including this one as to authentication services, and it was later codified into a regulation.
Here's my question for you. I follow it just fine. Is there a limiting principle?
Yes.
So what is it?
There are 4 limiting principles I'll give you, all of which are tailored to the statute. So clean text-anchored limits here. The first is it has to be an institution as distinguished from an individual. It has to be engaged in financial activities as defined by 1843K, which is a limited enumerated list, things like issuing annuities, providing investment advice, etc. And then with that catch-all of things that the FRB determined prior to 1999 were closely incident to banking, and it must be in the business of doing so, right? So it's not tangential to the business as the regulations talk about. And then the 4th limit is a BIPA-specific one. So does it come into possession of biometric information in the course of conducting those responsibilities? And providing office services to a financial institution doesn't fall within any of those limits. It's not an institution
if
engaged.
ABC Healthcare System was using a voice identification system, you with me on that?
Yes.
So all we're doing is we're taking Schwab out of it and we're parachuting in a hospital network.
Yes.
For patients to call in to check what they owe, check records, what have you. That way, what outcome there?
I don't think unless that financial or that healthcare institution in some way is providing financial services, that wouldn't be closely.
Yeah. So the nexus. So you see, at one key limit is the nexus needs to all happen under the umbrella of the provision of financial services.
Yes, Your Honor. That is the context of the FRB's 1999 order. They are The authentication is for customers who are accessing their financial accounts, as Schwab is alleged to do here. There is a voice ID to allow them to conduct financial transactions. The FRB order does talk about both financial and non-financial transactions, but it is in the context of accessing a bank account. It is, in the context of authentication for a bank, so that is a critical
So to the
limit.
extent you could read the district court analysis in McGovern more broadly, you'd say don't read it more broadly. You, the Seventh Circuit, don't read it more broadly. Read it more narrowly, because you limit it textually by statute to 25C. 25C is clearly talking about financial institutions. And then you limit it within the four corners of the Federal Reserve Board order as well, which is all financial institution. It's all in that context.
Yes, Your Honor, and I think that whether you find that textual limit in 25C or in the FRB order, it's very clearly talking about authenticating bank customers' access. So that provides, a firm limit on the extent to which this exception applies.
And assuming we're with you on that, how do we get there given the jurisdictional concerns and the concession opposing counsel made?
That they're not requiring Schwab to do anything. Well, I think that actually that just emphasizes why you should get there, is that what we have here is it makes pure policy sense in order to apply the GLBA to nuance under the allegations that are made here. So the GLBA is designed to protect information as it flows through the system, not just with the initial recipient of it, but to the subsequent recipients too, because otherwise what would happen is that the GLBA would apply to Schwab, but Nuance, who is alleged to come into contact with that same data, right, whether that's true or not, and we think it's not true, but it is alleged in the complaint that they collect and retain those voice prints in their databases. Otherwise, Nuance would be subject to 50 different state privacy laws, resulting in a terribly unworkable regulatory regime. And of course, that can't be the result of the plaintiff's position here. That's not what the Illinois General Assembly intended in making a broad financial institution exception in 25C. If there are no further questions, we would renew our request to be able to supplement our briefing on standing issues, and we ask that this court affirm.
Mm-hmm. Anything further, Mr. Wise? Or not?
One quick point, if I might, maybe 1 minute. Any limitation or any limiting principle has no basis in the text. Section 25C of BIPA references financial institutions under Gramm-Leach-Bliley, and the plain text of Gramm-Leach-Bliley merely incorporates financial activities as set forth in 1843K. There is nothing in Gramm-Leach-Bliley that says when a financial institution performs a financial activity for another financial institution, bank holding company, or financial holding company, that is a limiting principle. And so I think that is important, that, and this is what the ABA versus FTC case recognized, is that by having merely a definitional test, working backwards, simply meeting the definition is what would make one a financial institution, and that's the basis of our briefing that makes this a very, very broad and unworkable definition.
The court directs both parties to file within 14 days supplemental memoranda addressing the question whether there is an Article 3 case or controversy here. When those memos have been received, the case will be taken under advisement, and the court will be in recess.